It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. This is Attorney Matthew Noyes on a cold Clearwater day. Cold for Florida, I guess. Thank you for taking the time to listen to FLA Law on the radio. I am an attorney, a partner at the law firm of Perenich, Caulfield, Avril Noyes. We are the oldest and longest established personal injury law firm in Tampa Bay. We have been helping people since 1955 with personal injury matters. So if you have questions regarding personal injury matters, that's car accidents, slip and falls, even workers' compensation claims of Social Security disability, I'm here live on the radio from 5 until 6 today to answer those questions. But I'm not alone. I have my friend and my colleague, Bill DeMoss, here as well. Bill, thank you for popping in on this cold evening to be available to our listeners.
Oh, thank you very much for having me, Matt.
Sure. Why don't you introduce yourself to our listeners? Tell them a little bit about you and about your practice and what areas of law you do.
Sure. My name is Bill Demas. I'm with Herman & Wells. It is a law firm in Pinellas Park. I have been in the Pinellas County area since I was 2 years old.
So you were born in New York.
I was born in New York, but moved down here when I was 2.
Smart man. I know Matt on the other side of the glass is very happy whenever I say New York.
Yeah, I'm in New York myself. Whereabouts?
I was born in Brooklyn Memorial, and we lived in Ozone Park.
I got cousins that live over in Canarsie now.
Oh, awesome. Awesome.
So Matt, he's been down here since he's been 2. So.
Yeah, so you got me. You got the pants beat off of me. I've only been here 2 years.
So been down here basically my whole life. Was out of the Tampa Bay area just briefly to go to Florida State, and even came back here and went to law school in Pinellas County at Stetson. But my main practice now is disability litigation, dealing with short-term, long-term disability, either through a private policy or through work. Also, I handle life insurance claims, accidental death and dismemberment claims. So a bunch of these things that you either buy from the person that sells you your car insurance, or you get as a benefit through your employer.
Very good. So if you have any questions regarding all those areas of law, those are all the areas of law that when somebody calls me, I say, I know the right guy to call because I don't know how to do those areas of law. But if you have any questions regarding long-term disability, short-term disability, any type of insurance claims, I think you got the 2 guys here ready to tackle the questions that you have regarding the insurance claims. The number is 727-441-3000. Call us now. Oftentimes what happens is people wait till the end of the show to start calling, and then we run out of time to take all the calls.
And also, Matt, a small part of my practice is because it deals with insurance, because I do a lot of insurance work. It's first party property, the homeowners and property insurance too. Your house is damaged by a storm or a tree falls on your house or whatever. I do that too. So if anybody out there has some questions about that, I'll be happy to answer those.
That's huge in the news right now as well. So
big law changes. Yeah.
Yeah. Well, thank you, Bill. I appreciate you coming here. You are a busy man. You are married and have 3 boys, right?
Boy-girl twins.
Oh, boy-girl twins. Okay.
That just turned 22, and another son who is 20. Okay.
And you were active all the time when they were growing up. You're still active, aren't you, in their lives?
Still active. My wife and I travel up to Tallahassee for home games to watch my son play football at Florida A&M. And when he plays away games, we go watch him play football. Love it. Love going traveling to see our kids. We go up every time we can.
Yeah, and I think he has one more game, right? That's what we were just talking about?
Yeah.
Florida. Well, one more regular season game, and then you got to keep going, right?
Well, actually, the last regular season game was a couple weeks ago. They're going into their Division I school, so they're going into the SWAC, the Southwestern Athletic Conference Championship, and if they win that, they go
when they win that,
they go to the Celebration Bowl and play Howard. in the Celebration Bowl for the HBCU National Championship game.
Very good. We wish them luck.
Yeah.
Yeah. Now, before you came to the good side,
Right.
you were also an attorney working for the insurance company or doing insurance defenses, right?
Yeah, absolutely. I started my career in 1997 working for a firm at that point was Fox, Grove, Abbott, Bialik, and Kieran, based when it was Fox and Grove. That's how long ago it was,
Yeah.
Matt. And Matt, we had known each other tangentially because of St. Cecilia's and your siblings, and your mom was my music teacher at St. Cecilia's.
Yes.
Our connection goes back way before that, but that's actually when you and I first met because we had cases against each other. Yeah, so I was an insurance defense attorney for a good, almost the better part of a decade until the light clicked on in my head, and I said, well, what am I doing?
Yeah.
And then since about 2011, I've been representing solely injured parties and claimants.
But that 10 years of representing the insurance companies, that helped you in this area of law as well, right?
Well, absolutely, because any area of law where you're going up against insurance, there is the dynamic of the adjuster, the claims manager, the in-house counsel, things that they look at, exposure and risk. And then there's another part of the company that the insurance company doesn't want to talk about, which is the underwriting and the bean counters, right? The actuarials that say, we're going to be a little tight this month, so why don't we just go ahead and deny some claims or shortchange some claims? That's the way they do it. And I'm not speaking ill, Matt, but you've been dealing with insurance companies longer than I have. And the one thing I tell people is the only way an insurance company makes money is to collect premiums and not pay out claims. That's their only business model. So when people call me up and said, I can't believe they denied me, I turned around and said, are you mad when you go into McDonald's and they offer you a hamburger? That's their business model.
That's right.
There's no other.
That's true.
There's no other thing about it. But sitting in those rooms with those people, when I was on the insurance side, really opened up my eyes because I'm one of these guys that when I talk to my client and they go, what's going on in the other room? I know what's going on in the other room. I've had those conversations. So I can really help them through that period. It also helps with the insurance company too.
Sure. Yeah, you know how they react and how they behave, and so you can keep them in line.
Yeah, and also, Matt, this is not the type of attorney you are, and that's why we get along. There's some attorneys out there that's never been on the defense side or young and things like that think that if they go yell and scream at the wind, and I'm an attorney and I'm going to pick a fight and I'm going to fight over every little thing, that's going to impress their clients and get them better results. And I always turn around and say, I've been the person you're screaming at. And I'm sitting back with my adjuster going, okay, here's X amount more. It never changes our opinion.
No, I know.
It actually makes it harder to work with.
And that's why I think we've been friends for so long.
Right.
Because even when you were the defense attorney onto this side, we had mutual respect for each other. You handled your cases the right way, and we handled each other the right way. And I really think that's the way it should be when you're practicing law.
Absolutely, Matt. There's a few people that I can say you're one of them. When I say a few, meaning, there are some attorneys out there that I need everything in writing or send me an email, shoot me a text to confirm it. With you, when we had cases, if you said, hey, Bill, blah, 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 I need X amount of time, or I need a couple more days, or yeah, Bill, you need more time, you can have 10 days. I don't need a letter from you because I know you're never going to turn around and say,
handshake.
Yeah.
No,
it's your word. And I think that's why we got along so well, because we both practice that way.
And I think that's why you do so well in your ERISA and long-term disability and other areas of law that you do as well. So if you have questions regarding long-term disability, we're going to get into ERISA law, and we're going to get into long-term short-term disability. But it does look like we do have a caller on the phone. It looks like Victoria is on the phone. Victoria, thank you for listening, and thank you for calling in with your question. How can Bill and I help you tonight?
Yes, I have a question. If I'm already receiving short-term disability, do I have to apply for long-term disability, or does it just automatically happen?
That's a very good question, Victoria, and I got just the right guy to answer it. Bill, what do you tell Victoria?
Well, Victoria, that's a question I get a lot. And here's the thing. the answer is yes, but count on no. And the reason I say that is because they will tell you, oh, you don't need to do a single thing. Your short term will roll over to your long term. Don't worry about it. And the next thing you know, your short term ends and they're dragging their feet and they got to look for this and they got to look for that and da 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 da. So what I recommend people do is, as you're getting close to the end of your short term disability, you have 4 weeks, 3 weeks left, write the short-term disability adjuster and say, what do I need to do to file a long-term disability application? And when they say, don't worry, it'll automatically roll over, you go, yeah, okay, but I still want a copy of the long-term disability application. They can't say no to you. They got to give you a copy. So you have it. And what that does, when your short-term ends and there's that bog down in transition, you can just file your long-term disability application on your own and get the ball rolling.
That's good. Victoria, was that helpful for you?
That's great information. Thank you so much for your help.
Thank you for listening.
And one more thing, Victoria, I want to add that the short-term disability and long-term disability, the federal government and the federal law treats them as two distinct companies, both Prudential or both New York Life or whatever. So just think about this. Just because short-term disability has it doesn't mean that long-term disability got it or will see it. So what happens to a lot of people is it automatically transfers from short to long, and long-term disability sends them requests for documents or go get your medical records or fill out this form. And people sit at home and go, I'm not doing that garbage. You already have it. It's with the short-term disability. And then they deny your case because you didn't fill out the forms. So treat them as separate. Anything they ask you just to fill out, even though you filled it out before, remember you have to fill it out separately for long-term disability.
That's very helpful. Now, Bill, do they?
Thank you.
Thank you.
You're welcome.
Thank you for listening. Drive safely.
Yeah.
Thank you.
Sure. Bill, is the short-term disability and the long-term disability companies always the same company, or could they be different?
Oh, they could be different. They also could be a mix between an insured policy and a self-pay policy. So your bigger employers, Intel, Microsoft, Kodak, those are just off the top of my head because Bank of America is one I just got. Bank of America has their own short-term disability policy, meaning they pay it. It's self-paid. But they're insured through an insurance company for their long-term. So they buy insurance policies to cover their employees long-term, but they have their own payroll practice, they call it, which is a short-term disability program that they pay out of their own pocket. So sometimes it's a non-ERISA plan, an ERISA plan, an employer-paid plan, an insured plan. Sometimes it's, Mutual of Omaha, and then Lincoln. 90% of the time, they're the same because they sell it as a package.
Right.
But the other thing that is here is that, and this is something you can expound upon a lot because of your extensive background with workers' compensation, is that people get confused because when it's an employer-paid policy, meaning your employer is giving you long-term disability and they're paying for it out of their own pocket, or short-term disability, they're paying for it out of their own pocket, they implement third-party administrators, TPAs.
Yes.
So for those listening out there, a TPA is a company that acts like an insurance company, but all they're doing is adjusting the claim.
Right.
So basically, Bank of America hires a company to be their adjusters. And you deal with that in comp all the time.
Yeah, we call them the layers. Is what we call them.
Yes. So when people come to me and they say, I want to sue Sedgwick, and I'm like, well, they're not an insurance company.
Right.
They're just the administrators. So if anybody has any questions like that, they can call me and I'll be happy to answer that.
Yeah, and I guess we didn't say, Bill, where is your law firm and how do they get in contact with you if they need you? Not now, because they can just call you now.
You can just call me right now. But if something comes to you later, you can reach me at Herman and Wells. That's our law firm. We're in Pinellas Park. The number is 727-821-3195. 727-821-3195. And you can always reach me by email at bill@hermanwells.com.
Perfect. Yes, and it's a very good law firm. They've been around for a while too.
Yeah, Jason and Cliff have been attorneys for almost as long as I have.
Yeah.
Coming on, I think they're in their 20th year. I'm 25. And Jason was another one that was a big managing partner at a big law firm doing insurance defense. And I think almost a decade ago, him and Cliff got together and started working.
Good deal. And you're helping them out growing the ERISA plan and ERISA practice. And we threw out that word several times now, ERISA. Why don't you tell our listeners, what the heck is ERISA?
ERISA is an acronym for federal law.
Oh, surprise.
Yes. It stands for the Employee Retirement, the Employee Retirement Income Security Act. Even I have to think about it,
That's
folks.
pretty good. I had no idea. I know I say it all the time, but I couldn't tell you what the S stood for. So that's good.
And I practice it. It's a law that was founded in 1978, and it originally was founded to help monitor and with pension benefits, because back in the 70s, the big benefit people got was pensions, right? So it was set up to help monitor, pension funds and with the mob and all that kind of stuff. So that's but as benefits grew, people started health insurance outside of the automakers back then. Also, IBM's health insurance and disability insurance and this and that. Congress didn't know what to do with them. They're like, well, let's just stick them under ERISA. And those types of law really don't fit under that area.
Right.
That's why it's such a strange hybrid, half equity, half law area that, quite frankly, not a lot of people do.
Right. No, you are one of the few who fully understand it as well. Probably tinker with it, but ERISA is nothing you want to tinker with.
No, and when I tell people, when they say, well, I'm going to take a run at it on my own, I always say, it's not like Social Security. You can't get denied, and then call Matt after you deny and say, oh my goodness, I'm going for the judge. And then Matt can get involved with that Social Security case, and boom, 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 he can fix it. In an ERISA case, you handle the appeal by yourself. You don't do a good job because, quite frankly, you don't know what to put in. And even my attorney clients that do the appeal themselves, the law is different.
Right.
What they think is important is not important.
Oh, yeah.
And then what happens is now I'm stuck with a file. And what people have to understand is in an ERISA case, once you get your final denial and somebody then has to file a lawsuit, the only thing a federal judge looks at is what's in the insurance company's file when they denied the claim the last time. So if you didn't send in medicals, they're not there.
Right.
If you trusted the insurance company to go get your medical records for you, and I think Matt can speak on this a little bit, when people trust Social Security to go get their medical records,
sure,
they don't
have problems. No, you have to make sure that they do. And if they don't, you have to get them and make sure that they have them.
Because same with the Social Security law, in the ERISA law, it's even stated in the insurance contracts that it's the claimants. So you guys out there that have the policy, it's your job to prove disability. It's not the insurance company's job. It's not Social Security's job to prove you're disabled. It's your job to prove to Social Security you're disabled. It's your job to prove the insurance company you're disabled. So if you're counting on your adjuster, who part of their salary is bonuses based on profitability, based on denied claims, to go get your medical records and help you with your disability,
right?
What's going to happen, Matt?
No, that's for sure. You can see that.
It's not going to happen.
It's going to be denied.
Yes.
You know that for sure because they're not going to get the information to them. So ERISA is usually through the employer.
Right. Any policy that's provided through your employer, of course, there's some exceptions like those AFLAC policies that people get on the side. Those aren't ERISA. But if it's an employer that isn't governed by I say this is the easiest way to remember it. ERISA handles all employers that are not God or the president. And what I say by that is churches and religious organizations are not under ERISA.
Okay.
And the federal government.
Oh, okay.
And your state and local municipalities. Pinellas County School Board, not under ERISA.
Oh, I didn't know that.
We walk around the corner here and go to the City of Clearwater building. They're not going to be governed by ERISA. So government. So that's why I say God and the president. Those, if they're an outshoot of any of those, it's not covered by ERISA. Other way it is.
And sometimes government thinks they are God. So that's
I mean, so it's double.
Yeah. That's right. So what is the difference between getting a long-term policy through your employer and getting one through, on your own?
Sure. So the big difference is price and choice.
Okay.
Okay. I'm a firm believer that you get what you pay for.
Okay.
A lot of times these ERISA policies, so your group are so inviting to people, and I'm not telling people not to get them. Get them, get them, get them. Please get them. But they're $15 a month, $30 a month, something like that. Sometimes the employer just pays for them.
Yeah.
You don't pay anything. Well, your employer can either buy you the Maybach Ferrari of insurance policies, or they're going to say, well, let's just get them the bare minimum, just strip down, what we used to say, a Yugo from, beater of a car.
Right.
That's the policy. So you're stuck with the policy that your employer has gotten you. That's going to have all these exclusions. They're going to have all these limitations. They're going to have all these conditions that they don't cover, all these rules and regulations.
Oh, okay.
And you have a choice. You either pay for it or you don't, but you don't get to choose it like a Burger King menu.
Sure.
Your private policy is one that is exactly like you would go to get your car insurance. You sit down with the same gal that sells you your car insurance. Yeah, I want a disability policy, and I want it to cover me for this set amount, not a percentage like your ERISA policies are, but I want it for, $5,000 a month if I become disabled. And they're going to give you a policy. Then you look and say, you know what? I don't like this exclusion for mental health. I don't like this exclusion for XYZ. I want this rider. You can pick it. Now, it's going to be much more expensive.
Right. But you get what you pay for.
You get what you pay for.
Right.
And also, it's exempt from ERISA, which means that if they deny you and you come to me, we're suing in state court. We get a jury. We get discovery, meaning that we can go and ask the adjuster why they made the claim decisions and depose the doctors and their doctors and all that. And we're having a full trial.
Okay.
Under ERISA, it's federal court. Just so people out there, there are federal court judges. I think they're all awesome, but there are some federal court judges that are sitting in the Middle District of Florida that were first appointed by Nixon, denied, and then reappointed by Reagan, and they're still on the bench.
Oh, okay.
Okay. And you have to understand something about a federal judge, Matt, and you know this. They're the closest thing that we have to a monarchy in the United States. They're appointed for life. There's no age limit.
Right.
And it's almost impossible to get them off. So you're in front of a person that making your decision that basically can do whatever they want, not 6 people that live in your neighborhood,
right.
Which I think is huge.
Right. No, I agree.
The other thing is in an ERISA case, you're in federal court, which means that there's no discovery in ERISA cases in federal court. So after I file a lawsuit, I can't depose the adjuster unless extraordinary circumstances. There is a case, a Middle District case out there, Cerrado, that says that we can, but in only very limited situations.
Wow.
Like you look at the claim file and the adjuster notes have 4 months missing when they produce it in the Rule 26. Yeah, you can take the deposition and go, well, you didn't work on a claim for 6 months, but that's about it.
Wow. Okay.
You can't go depose.
So you're very limited.
You can't now go to depose a doctor. You can't do this. In fact, these cases are decided upon a written submission called a motion for summary judgment. So the client, and you guys have to listen to this, if you do your ERISA case wrong, you don't have a choice. You don't have a chance to go explain it to the judge because you don't get to testify at your own trial.
Wow.
Because your testimony is not in the record when it was denied. So the federal judge does not look at it.
That's why it's so important to hire you sooner than later.
Right. There is no, let me do the appeal and then Bill or Matt will figure it out and prove my case. I told you before, I could be Chuck Yeager. You build me a plane with no wings, I'm crashing.
Right.
If you do it yourself, you're literally building a tube and there's no way I'm going to be able to fly it.
Right. I use that analogy when I'm talking about handling auto claims for
Right.
my clients. It's like me trying to fix my air conditioner at home. I could tinker with it and see if I can get it to work.
Right.
But it ain't going to be working for long. And,
No.
and then what's going to happen is I'm going to do something so bad that either it can't be repaired or it's going to be very costly to get it repaired.
Absolutely. So the main thing is that people have to realize is these insurance companies, especially on an ERISA case, there is no need to rush legally. Now, I get it. You're disabled. You're not getting your money. Bills are piling up. We are not insensitive to that. We get it. It's real life. We all have, we all have bills. Here's the problem is that nothing ever, fast never equals good in the practice of law.
Sure. I understand that 100%.
Right? So if you rush, you always fail in law because you haven't spent enough time doing it.
Right.
The ERISA regulations, after denial, gives the claimant 180 days, 6 months to appeal. We have time.
Right.
Let us build the appeal. I can't go to your doctors after the appeal is denied and get their opinions, but there's no rule against me taking their recorded statement, taking their depot before the appeal is done.
Okay. Yeah.
Okay. There is no law with me getting doctors to fill out forms, like similar to what you do in Social Security. You won't be able to testify. The claim won't be able. Well, we have ways to get their testimony in the record.
Sure.
So if the insurance company denies it and I have to go in front of a federal judge, I can cite to my client's own testimony inside the record. If somebody just writes a letter, says, I appeal, which they do sometimes, send it to the insurance company gets 2 more records and denies them. How do you win that case?
Then you're done. Yeah.
You're done.
That's why it's so important that you take the time and you build up the case. You need to build up the case in order to at least have a good record for the judge to eventually look at. Right.
And remember, the ERISA cases are also a lot harder because it's not like your non-ERISA cases, your private policies or a policy through a church or a government entity where you go in front of a jury and it's the burden of proof, Right. 50%, did I win more than 50%?
Am I disabled? Yeah.
Right. Am I disabled or not?
Meet the qualifications.
The federal, in the ERISA law, there's 11th Circuit case out there that lays out these 6 factors. I'm not going to go through them all about how they decide an ERISA case. And the first one is the judge decide whether or not the client's disabled. If it's no, then the person loses. Right. But if it's yes, then they look to see whether or not the insurance company was reasonable in their wrong decision. Wow. I'm going to say that again. Reasonable in their wrong decision.
Right.
What I said before about being built from pensions, they're using that same type of equity because if your investor back in the early 80s, your service investor put all your money into Betamax and it lost, you try to sue them, they'd go, well, in hindsight, it's a bad investment, but at the time it was reasonable.
Right. No. Mm-hmm.
So that's how they do these cases. So the insurance company could be wrong and you still can lose your case because they were reasonable in their decision. They relied on a doctor who the judge thought was reasonable.
Right.
Even though he was wrong.
What are the main reasons why somebody could be denied under a long-term disability policy?
The main reason that I see is doctors not cooperating, meaning not sending in medical records, or the insurance company claiming that the doctors never sent in medical records, and I'll circle back about there's an easy way to fix that, is most of these policies have a change of definition of disability, meaning for some short time, you're disabled if you can't be a lawyer. Matt, it's your own occupation. You're disabled for 12 months, 24 months if you can't be a lawyer.
Okay.
But after that, you're disabled if you can't do any job in the national economy.
Oh, wow.
So can you be a greeter at Walmart?
Right.
And the difference between this and Social Security, a lot of these cases have no earning qualifiers. It's whether or not you can go make minimum wage at the, wherever,
right.
At Walmart, then you're not disabled.
Wow.
So they have this huge policy and people are paying on these policies and they're, working in an office staff or whatever. Next thing you know, they turn around and say, yeah, well, you can go be the hostess, down the street, or you can answer phones. Like for you, they turn around and say, well, he knows a law business. He can answer phones at a law firm.
Wow.
Because it's any job. And that's
because it's the change in definition. Oh,
right.
Okay.
And that's why those private policies are so important, because it's the Burger King menu. You can say, you know what? I don't want any occupation. I want it to be, if I can't make 80% of what I was making, 50% of what, sure, you're going to pay more money.
Sure. But you're going to have better protection
have
later,
better coverage
when you need it.
Right. And that's something also I'm happy to do. If anybody has a policy that they want, they don't know what it's about, or, they have one and now they're worried about it, they can call me up, make an appointment with me. I'll be happy to review it for them. I'm not going to charge them. I'll be happy to take a look at it and tell them what they got, because a lot of times people don't know what they got.
Yeah, that's perfect. All right, I think we're going to take our first break. While we're on break, the number is 727-441-3000. Give us a call. Bill is here to answer any questions you have regarding long-term disability. We're going to talk about life insurance a little bit, as well as other areas of law that Bill focuses on. So give us a call, and we'll be right back.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Perenich, Caulfield, Avril, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident, or after a loved one sustained serious injuries due to someone else's negligence, call Perenich, Caulfield, Avril, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
We are back. This is attorney Matthew Noyes, and this is FLA Law on the radio. Please give us a call. We're here for about another 20 minutes. This is a live legal call-in talk show. We're here to answer your questions regarding the law. The number is 727-441-3000. And I'm not here alone. I'm here with my friend Bill Dimas, but I understand I've been saying that wrong for like 30 years now, though.
Yeah. Well, it's so funny because the way it's spelt, and I don't correct people.
You should. 30 years ago, you should have corrected me.
I know it's Dimas, but the way it's spelt is Dimas, but it's shortened from Dimakopoulos, which is my dad's original name when he came over to this country.
I would have really been pronouncing that one wrong, though.
Yeah, Dimakopoulos had a good, strong Irish name. But it's Demas.
Demas,
yeah.
Yes. So Bill is here to answer any questions you have regarding long-term disability, short-term disability. We were talking about the insurance companies denying the claims and getting your ducks in a row, being ready before you actually file the appeal. Mm-hmm. Because as Bill was saying, you got to have the proper parts of the plane in order to make it fly.
Right.
And it takes a lot of work.
Yeah.
I mean, even an attorney that has a disability claim won't know how to do this correctly. A doctor wouldn't know how to do this correctly. An electrician certainly wouldn't know how to do this correctly. And so it's important that they contact you before the final decision's made.
Right. Because Matt, I mean, right now I could sit here right now and for correlate between our practices, Social Security and long-term disability, they're both disability practices. Well, what's the one thing that people that do their own Social Security claim miss? They have the doctor go, I'm disabled.
That's exactly right.
And the federal judge or the administrative law judge in Social Security will turn around and go, well, he's a medical expert, not a vocational expert. So a lot of times people say, well, my doctor says I'm disabled.
Oh,
I
we hear
win.
that all the time.
And guess what? You don't, because the doctor's not qualified to say whether or not you can work. That's why you need to come to, for Social Security cases, Matt, for long-term disability cases, me. And what we do is we have the breadth of knowledge, and we can sit there and we can prove that you vocationally can't do it, which is a totally different language than, other attorneys talk. I do a little bit PI, you do a little PI. You talk to some of your PI brethren and you start going into vocational, and they're like, what are you talking about? It's just a whole different, you have it with work comp too. You have to have the vocational and the work comp. It's a whole different language that even attorneys that do injury don't speak.
Right.
So how can, as you said, that electrician, hardworking guy, probably smart, or a pharmacist, she may be top of her class in pharmacy school, but I can't dispense drugs, and she can't write about this disability.
Exactly true. Right? Exactly true. And your practice and our Social Security disability practice are very commingled. They could be very commingled, but they're also very different.
Right.
Can you tell our listeners how they are different? The SSD qualifying for Social Security disability and qualifying for long-term disability.
First and foremost, I want to say just before that is that people who apply for long-term disability need to expect themselves to be forced. I'm saying forced because the policies force you to apply for Social Security disability.
I see that all too often.
And the reason is, as you know, Matt, is because the insurance companies get a dollar for dollar offset on what the people get from Social Security. So what they'll do, people, is you'll have New York Life will turn around and say, oh, you have to apply for Social Security, but you know what? We're going to provide Gen X, or we're going to provide XYZ service to get you Social Security.
That drives me crazy.
Matt, when's the last time that you've heard an insurance company doing anything for your clients for free that didn't benefit them?
Exactly true. That's what I always told the people that come in with, oh, I've already started the process because my long-term disability told me to go to X, Y, and Z. And so they started the process. Who's looking out for you in that situation? They're looking out for the long-term disability policy.
Because what these people don't realize is that when they sign up with these companies, okay, a lot of times, and I'm not speaking about any company in particular, I'm just speaking as the industry standard, a lot of times your case is not handled by an attorney until just before the final hearing. And we know people in the area who are attorneys that do this work, right? And they have a pipeline. All they do is get a file, show up for the hearing. So they haven't worked up the file.
Right.
Okay. So I mean, like you in your office, you're hands-on in that file.
Yeah, from the way beginning.
Right.
Yeah.
And you're meeting with your staff and you know what's going on, and they can call you on the phone and they're speaking to an attorney. Same way with me with my long-term disability. The other thing that people have to realize is when they sign up, they usually have to sign a paper that says that their Social Security advocate, their attorney for Social Security, whoever's representing them, can talk to the long-term disability company and adjuster about their claim without them.
Yes, that's crazy.
So from a Social Security standpoint, Matt, tell me why that's a bad idea.
It's just a horrible idea because the interests, who are the best interests of the injured or the disabled is not being looked at. It's being the best interest of the long-term disability company is what's being the main focus of that.
And especially when you have these policies that have exclusions. We're only going to pay for 24 months for a mental disability. And so what they do is these companies miraculously, you know what? Your knee claim is tough. Your back claim is tough. You know what's a winner in Social Security? Your depression. So they go all in and they prove disability by mental disorder. And then they get the award from the judge and they send it to the adjuster, who promptly says, we're no longer paying you in benefits because a judge determined that it was mentally caused.
Yeah.
Where you're going, well, how about my knee? How about my back? Well, they didn't really mention it to the Social Security people. I've seen that. I've seen people come to me so many times with these Social Security awards and their long-term disability is denied, and then I have to go and I have to prove that they're disabled vocationally and medically, whereas that should have been done if they had hired you in the beginning, and you proved the case like you should have, physical and then mental. Guess what? You don't call me. Right. And the other great thing about Matt, folks, is Matt and I worked a long time together, is that whenever I send him a case for Social Security from a long-term disability perspective, or he sends me a long-term disability case because he's got the underlying Social Security case, the first thing I do and the first thing he asks for is a copy of the insurance policy, because he gets the policy and he reads it and he knows what exclusions are in the policy.
Right.
So if it's excluding mental disability, Matt's trying to prove you're disabled from the physical standpoint in order to preserve both claims.
Right. That's important, because it doesn't do any good to win solely on Social Security disability if you would still be entitled to the long-term disability.
Right. But here's they both have, Social Security and long-term disability have different definitions of disability. You can, your people have heard you talk about the Social Security definition. I know it because I just need to know it. It is basically you can't do any job in the national economy and earn a certain amount of money a month. I think this year it's $1,400.
About $1,400, a little more than that.
And change, right? Yeah. Well, the Social Security, the long-term disability is based on what your what the policy says disability is. So it's kind of like a rule book. Why is a 2-point shot 2 points, and then in basketball you move behind a line a centimeter later it's 3 points? Why is a field goal 3 and a extra point 1 where they're the same kick? Because the rule book says so. It says
so. That's right.
What's disability in long-term and short-term disability policy? There is no common definition of disability. It's not codified like Social Security.
Right.
It's whatever the insurance company says disability is.
Okay.
So that's why you have to get the plan, get the disability plan, and you need to read it. You can't win the game if you don't know the rules.
Exactly true. That gets you into trouble all the time.
All the time.
And too many people are trying to play the game.
Right.
And without knowing the rules. And that's why it's so important. Does look like we have Tanner on the line. Tanner, thank you for listening and calling into FLA Law on the radio. How can we help you tonight?
Hey guys, I actually have a question. It's kind of a two-parter.
Okay.
But say I get insurance or forms from the insurance company. Do the doctors have to fill that out? And if they do have to fill that out, do they then have to charge? Can they charge the patient?
That's a good question, because we do see that in Social Security a lot. But what about in long-term disability?
It's a great question, and it's one of the main reasons why clients are denied is because their doctor refuses to participate in the disability process.
Okay.
Sometimes they're more willing to participate in Social Security because they know they'll never be hauled off in front of a judge. But some of these doctors, they don't want to get involved in these long-term disability cases. So, Tanner, the answer to your question is no. Your doctor does not have to fill out those forms. The second part of your question, unfortunately, is yes.
Of course.
Of course.
Can the doctor charge you? Of course.
Of course. Now, I've told people that there's an easy way to do that. The easy way to get the doctor to fill out the form is make an appointment. Go see your doctor. Don't give the form to the office manager, to the nurse. When you see the doctor or the nurse practitioner or the whoever sees you on a basis, not just the intake nurse, say, I need you to fill this out. Go through it already so you know what the answers are. We can talk about it. I've already looked through it. And then you say, if there's a charge, what is it going to be? I find that when I tell my clients this 90% of the time, a doctor is not going to look at you and say, give me $50, give me $100.
Right.
Their compassion and their ego won't allow them to do that.
That's right.
Okay. However, their office manager, who is the pit bull at the gate, and we all have him in our offices, right? Because we need him.
Yeah.
They have no shame of saying, give me $100.
That's exactly true.
And at the end of the day, you may have to pay for it, but you have to judge it. That's why it's very good to talk to somebody about it, because I tell my clients all the time, I know it's $100. I know it's $200, but you're going to trade that $200 for $2,000 a month, $3,000 a month for years.
Right.
It's worth the investment.
Yeah. Tanner, does that answer your question for you?
Yeah, that answers my question exactly. Thank you, guys.
Tanner, thank you very much for listening. Have a great night. Now, we've been talking about long-term and short-term disability, but that's not your only areas of law. We have, probably about 9 more minutes. Let's talk about life insurance, because I see that happens a lot. We get a lot of calls, hey, my loved one has passed away, and now we're fighting about the life insurance. Why would an insurance company fight about a life insurance?
That's a very interesting question. One of the fight is, if you talk about denying life insurance.
Yeah, I mean, they're either dead or they're alive.
Right, but there are exclusions.
Okay.
Have calls of where, some life insurance policy have drug and alcohol exceptions.
Okay.
So let's say he's in a car accident and he's driving and he's got a blood alcohol, any alcohol in his system, not even above the legal limit, any alcohol in the system or her system. Or we had a case where a gentleman was at a hotel and had taken his nightly pills, just prescribed, and said, I need a drink of water, and went down to the vending machine, stepped down, unfortunately fell down the stairs and broke his neck.
Oh, goodness.
And the insurance company, we had to fight it. They were denying it because he had taken his nighttime medication before he went down the stairs. And it was in his system. And they don't even have to prove that it contributed. Some of the other reasons are that they didn't die, that in the manner in which they passed is almost, I have to say, meets one of their exclusions, but really not fully. But the policies, a lot of these policies give them what's called deference, that they get to interpret the policies. So they say, we think, and we're interpreting what we see here, and this language, it covers this. So it's truly a mixed bag. Sometimes it's because they've been collecting premiums from you for 5 years and then realize that you didn't sign a form. And like, well, here's your premiums back. We're not covering you.
Oh, my goodness. That's crazy. That is crazy.
Mm-hmm.
And the family's already suffering through their loss. And then
suffering
they have to deal with that.
their loss. The other reason that there's problems is on the beneficiaries, the people that get it. The ex-wife is on there, the mother, and then they get married, and then so there's a couple people fighting over the proceeds. That's something else I do where where the insurance company has their hands up in the air and says, we don't know who to pay, so we're suing everybody that claims it, or because the court's got to tell us who to pay. It's called interpleader. We're happy to pay the money. We just don't know who to pay it to. So a lot of times, and that's something else that you guys should really think about out there, in a policy that is through your work, you need to update your beneficiary every year, because if it's your ex-spouse who you hate that you got divorced from 5 years ago and you're now remarried, if you die, your ex-wife gets it.
Wow.
Okay. Now, if it's a personal policy in Florida, there's a rule that says once you're divorced, on a private policy, once you're divorced, the ex-spouse is automatically off.
Oh, okay. So that's another difference between the ERISA and the private.
Right.
That's very good.
But in ERISA, if your beneficiary is your ex-spouse and you hate him with the heat of 1,000 suns, he gets your money.
Wow.
So we see that all the time.
I see a lot of benefits getting a private disability policy as opposed to the ERISA.
Right.
It's that one of them, but they also is that you get to do that whole discovery. You get to take the depositions and get the information.
Right.
But I think it's also, as I think what you talked about, is the decisions made by a jury,
right,
and not a judge.
And they have to be, the insurance company has to be right, not just reasonable.
Right. That's
the huge difference. You get to look at an insurance company and say, you're wrong. And the jury says, yes, they're wrong. And you win. In federal court, you go, Your Honor, they're wrong. And he says, yes, they're wrong. but they're not being unreasonable. It was reasonable for them to rely on 3 board-certified doctors, who, by the way, are all employed by the insurance company.
Yes.
It was reasonable for, instead of the client's 10 doctors. That's reasonable.
Yeah.
And with a federal judge, they're making the decision.
Right. What about the appellate process? Is there a different appellate process?
No. Well, it's a federal appellate process. So if you don't like it, if you don't like something that's done out of one of the districts in Florida, the Middle District of Florida, that of course is appealed to the 11th Circuit Court of Appeals that handles, the three lower states here. And then if you don't like the 11th Circuit, it's to the Supremes.
Right. And state court, though, I mean, I think you have a little more flexibility.
Right. State court, you go from the state court, then you go to if it's around here, the second DCA. And then from there, you'll go to the Supreme Court of Florida.
Right.
But the important part of it is that a jury is making a decision to help you or not. And it's not a person that's sitting up high in their ivory tower making a decision on your claim without looking or hearing anything more than reading papers.
No, that's true. That's true. That's so important. So the private disability route is the way to go.
Right. But again, if your employer is giving it to you, take it. But
know what you're taking.
Right. Know that you're buying in most cases, a 10-year-old, 12-year-old, 15-year-old used car with a gasket leak. That's right. What you're getting. It's going to get you around, and it may not be pretty, but it's not going to be your Cadillac. Your Cadillac's going to be your private policy.
Right. That's important. And I was going to talk about accidental death and dismemberment, but I'm going to have you come back another week in order to do that as well. Bill, I really appreciate you taking the time to answer the questions. I've learned a lot in the last hour, so I appreciate that. Why don't you tell our listeners one more time how they can reach you, and again, your areas of focus or specialty?
Yeah, well, my name is Bill Demas, D as in David, EMAS. I'm with Herman & Wells. The phone number is 727-821-3195. And I am an ERISA and life insurance and disability attorney. If you have any questions with any of your disability, any of your insurance policies, anything like that, from home to disability to life, give me a call. I'll be happy to help you.
And Bill does the same thing that we do at Perenich, Caulfield, Avril Noyes. If you just really want us to review your car insurance policy or your disability policy, we'll do that, and we'll do that without a charge.
Right.
And so I think it's important. That's a way of giving back to the community.
And just like with car insurance, Matt will tell you this. He's probably told you this before to the loyal listeners. I say the thing with disability in life, there is no such thing as full coverage. Do not believe it. Always read it.
That's exactly true. That is exactly true. Well, this is Matthew Noyes, and we appreciate you taking the time to listen to FLA Law on the radio this evening. We are here every Tuesday from 5 until 6. Attorney Jacqueline Bryant will be hosting it next week, I believe. And she will be here with another guest to be available to answer your questions. So again, thank you for listening. Drive safely and watch out for those who don't. Take care.